Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in Australian industrial relations law and practice. Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. My name is Rohan Doyle. I'm a partner in the industrial relations practice at Herbert Smith Freehills. And you're joining us for our 27th episode of Inside IR, where we'll be covering managing picketing in the workplace and how to address our workplace health and safety obligations in doing so. And we've got some of the best in the business joining us to help us with that topic today. We have Senior Associate Emma Vautin and partner Steve Bell. Welcome, Em and Steve.
Hi, Ryan.
Em, your first episode of Inside IR. It's great to have you on the podcast.
First episode, and delighted to be here with you and Steve.
And Steve, seasoned campaigner, probably fresh from filming your latest episode of Inside Safety. Do you want to give that a bit of a plug?
Yeah, well, I think this is what my kids call a collab. So I'm excited to be here. We've got a sister podcast to this, Inside Safety, but this will cover both topics today, Rose. So looking forward to it.
Yes, we did have a brief demarcation dispute about whether this was a more appropriate topic for Inside Safety.
And I had to look up what that was. So that's
Inside IR wins because, unfortunately, as we'll see as we go through the episode today, managing picketing is very much an IR issue. Picketing for those that aren't seasoned IR campaigners is, of course, where you have a congregation of people standing outside, generally the workplace. Sometimes it is obstructive and prevents people and vehicles from getting in and out, and it is sometimes used to create leverage for claims, for example, bargaining claims and the like, and often used as quite an effective industrial tool to impose pressure on employers. Now, picketing, it's a topic close to our heart at HSF. We've been involved in helping clients with some of the most significant obstructive pickets over the years. Back to the waterfront dispute in the late 90s, the Grocon dispute back in 2012, more recently in 2018, the 4X brewery dispute, which led to the making of the first good faith bargaining orders and the commission to stop a picket. But there's actually many more than that, and many that actually don't make the front page of the press. And in our experience, we're seeing an uptick in the types of this behaviour, an uptick in unions and others using these tactics in order to impose pressure on employers, particularly in the course of the enterprise bargaining process. And those pickets can have a real impact. We'll wind back, all of us will remember, of course, the dispute from back in December 2024 involving Woolworths.
Yeah.
We saw that lead to empty shelves during the very busy lead up to Christmas. And in fact, Woolworths came out and announced to the market on 9 December, keeping in mind this was midway through the dispute, that the estimated direct one-off negative impact of the dispute to date, that's the industrial action and the picketing, amounted to approximately $50 to $60 million. So that's pretty material. And for that reason, it's really important that employers, particularly those heading into enterprise bargaining rounds, are prepared. They know what to do if a picket surfaces in the workplace. They know what to do in advance of the picket arising. They know what evidence to create when it's on. They know what they need to do to manage their health and safety obligations, what to do to ensure that there's safe access and egress for their people, their contractors, their labour hire, and also what mechanisms are available in the courts and the commission to actually seek some assistance if they need to do so. So Steve, Em, that brings us to the content of today's episode. We're going to do 5 things. First, Em, you're going to take us through what are the key conduct and safety issues that are likely to arise or sometimes do arise on picket lines. I'll then touch on why is it that pickets are often so effective and relatively common. Third, Em, you'll take us through a recent case that I think gives a real practical example of some of these challenges. And then fourth, Steve, we'll throw to you. Hopefully you've got some answers for us on all of this.
Sure.
What role does health and safety law have to play in the management of obstructive pickets? Who has what obligations? How might they be used to promote a safe worksite during those periods? And then fifth, Em, you and I will finish off with a bit of an outline of some of the legal response options available to employers in the event that they're confronted with an obstructive or intimidatory picket. So Em, over to you. What can you tell us about the conduct on picket lines that sometimes give rise to health and safety risks?
Thanks, Rohan. So the conduct that we can see on a picket that can lead to safety risks really falls into two buckets. So there are those physical risks that arise. As Rohan referenced, the most common of those, the conduct that we see on a picket are individuals or cars obstructing access to a site, and that's sort of what it makes it a classic picket line. Other physical behaviour that can arise on a picket can include actual or threatened harm to individuals. So that can include things like shoving other people, throwing items, rocks, bottles, thumping on vehicles that might actually be attempting to cross the picket line, because often emotions are running quite high on a picket line. And in addition to that, we can see, damage to property, and that might be things like tyre slashing, graffiti, or damage to perimeter fencing. So all of those types of conducts can obviously lead to a risk of physical injury. But there are also psychosocial risks to health and safety.
Yep.
So typically we hear implied or even explicit threats of reprisal against individuals, employees or contractors who might be attempting to cross the picket line. So these threats can include threats of physical violence, but it can also often include threats of black banning. People or contractors, won't be able to work on future sites. And there's, of course, just verbal abuse as well. The word scab is a really emotive and meaningful word in the industrial context, and that word can often be sort of thrown at individuals who are trying to cross the picket line. Often there can be, particularly in Victoria, certain large inflatable characters who turn up at these pickets, Scabby the Rat and Fat Cat. They're more there to create a sense of theatre rather than creating any kind of particular threat.
But it's all about the social media attractions, those sorts of
Well,
things, isn't it?
exactly,
I mean, this is part
yeah.
of the
That's right.
part of the power, I suppose, of the modern era and these sorts of, the theatrics that go with all of this.
And, a shot of Scabby the Rat looks great on the Facebook page for whatever particular campaign, that the picket is supporting. So those are the things that we typically see.
And he gets around, Scabby. We've seen him all over the country, haven't we, Rohan? We've seen him in lots of...
Suspect there might be multiple versions.
Oh, that's interesting. There we go. I think you heard it here first. Yeah.
So these threats, they can create a psychosocial risk to health and safety to those targeted. And in some instances, individuals, employees or contractors can be genuinely concerned about their safety. And when I talk about the CBB contractors case a little bit later on, there was an example in that case where an individual who crossed the picket line was actually attacked in his own home, apparently in retaliation for crossing the picket line. So those sorts of instances, while sort of certainly rare, can and do happen.
Thanks, Em. I mean, these are very serious issues, and of course, there's a continuum on which pickets sit. Some are very peaceful, and there's nothing wrong with a lawful, peaceful process undertaken on non-private property. I mean, generally that's okay. At the other end of the spectrum, you have some of the conduct that you've run through today, Em, that can be quite legitimately frightening to be a part of. And unfortunately, these things do happen, and in our experience, relatively frequently. That won't be a surprise to the seasoned IR campaigners out there, but it might be to the general public. This is a relatively common occurrence, which gives rise to the question why. I mean, all of the things that you ran through, Em, are unlawful. Blocking access to sites is unlawful. That is, under no circumstances is that an acceptable form of conduct. So why does it happen so often? Unfortunately, it's really effective. It works. I mean, as we saw with the impact on Woolworths, 50 to 60 million midway through the dispute. Yeah. I mean, that is serious. And why do they work? That's a complex question. There's a range of factors that go into that. And I'll run through those briefly. I mean, the financial consequences is a good one. But also, Steve, you touched on this, damage to brand. You get Scabby the Rat out the front, you get an angry mob out the front chanting slogans, you will get pretty close to front page media coverage. You will get good content to put up on social media pages and the like. And it gives unions in particular a platform to sell their message, their version of the dispute and the issues that workers are fighting for. And that has a real impact in this day and age and on brand. We also have the problem that it's actually pretty easy to obstruct access to sites. You only need one protagonist to do that. One person can stop a truck. You just got to stand in the right spot. That is another challenge to deal with. It's also sometimes hard to get evidence that you need in order to get relief from the courts and the commission. If you don't have someone that's standing within earshot of what's being said to the people trying to access or exit the site, the people in the trucks, the people on foot, people in cars, then you'll inevitably get the response that, well, these people just voluntarily decided not to enter. We didn't obstruct them, we didn't intimidate them. They just decided to support the cause of the picketers. That's often the response. Now, sometimes that's true, but sometimes it's not. And the only way to distinguish between those two is to have the evidence, hear what's being said, observe the conduct. Even when you do have that evidence and you get the orders, we've also got experience that the orders don't always work. We saw reports in relation to the Woolworths dispute that orders were obtained against the UW to stop the obstructive picket. Reports suggest that the picket continued, albeit with the help of people not covered by the order for a period. Now that happens. It's sort of colloquially known as the community picket. And it sometimes requires multiple visits to courts and tribunals to get multiple orders to deal with that conduct. Now that's a good snapshot of some of the challenges in this space. Now there's solutions to all of those issues, and we'll sort of come to those a little bit later. But one of the most significant challenges, in my view, and the genesis for this particular topic on the podcast, and the reason for your presence, Steve, is that often safety concerns are used as a tool to make a picket effective. And that's done in two ways. One, actual safety risks. Em, you've spoken to those. Implementing sort of conduct, saying certain things to people that engender a fear and actual safety risk that will prevent people from crossing. But the second way it's used as a tool, sometimes there's no actual safety risk, but there is nevertheless a perception or a hesitancy on the part of people to actually cross the picket line. You might get employees that are hesitant to cross out of that fear. You might get contractors and labour hire that are hesitant to cross because of that fear. And the problem you have in that scenario is if the employer of those contractors and labour hire says, I'm not comfortable with requiring my people to walk through that picket line, and they give the authorisation for their people not to walk through, well, that's not industrial action. And there's not really any relief that the principal, the site owner, the employer can get in response to that conduct in many cases. So that's a real challenge. And I think, Steve, we're going to come to you shortly on your thoughts on that particular challenge. But Em, I understand you've got a recent case that's been through the courts that sheds some light on this particular issue.
Yeah, absolutely. So the recent CPB 418 decision, which was handed down last year, is a really great case study of the intersection between the safety and industrial relations issues that we've just been talking about. So CPB is the principal contractor for the Cross River Rail project in Brisbane. There are, I think, at least 16 construction sites in Brisbane connected with that project at the moment. And all of those sites were affected by protected industrial action in 2024. So while CPB, as the principal contractor, only has around 200 direct employees who were taking this industrial action, they also set up a picket line at each of these sites. And once they did that, around 700 to 1,000 subcontractor employees on any given day were failing to turn up to site. And that was causing significant disruption to work on the site, understandably so. So in August 2024, CPB filed an application with the Fair Work Commission seeking a Section 418 order against the subcontractor employees, alleging that those employees were engaging in unprotected industrial action by failing to cross the picket line and turn up for work. So somewhat surprisingly, most of the subcontractors actually opposed the application on the basis that it wasn't industrial action because they authorised their employees not to attend the Cross River Rail project sites due to the physical and psychosocial safety risks of crossing the picket line. So, as I mentioned a bit earlier, there was some evidence provided to the Commission of individuals being personally targeted for crossing the picket line. And in particular, the subcontractors alleged that CPB, as the principal contractor, was not doing everything reasonable that it could to eliminate or mitigate those safety risks. And ultimately, the Commission accepted this argument, amongst other reasons, and refused to make the 418 order.
So, Steve, that sets some pretty good context. I mean, this is
Sure.
a scenario that we see quite commonly. There is a picket line that's formed out the front of a workplace, generally in pursuit of claims in bargaining and the like. The principal, the employer of that workplace, has both employees, contractors and
Sure.
labour hire that often turn up to work.
Yep.
It's not the contractors and labour hire that are engaged in the actual dispute. They're not taking industrial action per se. They can't. That's not protected industrial action. The principal, the host, the employer, they want those people to turn up at work, but there is a concern about crossing the picket line.
Sure.
How does safety law sort of interact with these issues?
Well, look, I suppose we start from the principle that there are duties of care on all sides here. So, you're quite right. The employer has a positive duty of care to do a few things. One of those is to make sure that there is safe access and egress to the site. So that's the host's obligation to be satisfied of that. And that's irrespective of whether somebody else chooses to pick it or not. There is an obligation there on an employer to make sure that people can come and go, to make sure that emergency services can come and go, to make sure that essential maintenance can be performed. So there are, duties on the employer first and foremost to do what it can to address the sorts of circumstances that we've been talking about. But the health and safety law is expressed in really broad terms. In addition to that, there's a duty of care on anybody conducting an undertaking, and that would include protest groups, it would include third parties like unions, it would include those who might be organising, community blockades of workplaces, and a duty of care on them too to do everything they reasonably, practicably can to make sure they're not putting people's health and safety at risk. And as you've said, Em, when we think about health and safety now, we've got to think pretty expansively. It's not just about physical health and safety, it includes mental health, it includes psychosocial health and safety as well. So there's a broad set of duties here that apply across a range of these stakeholders. And I suppose it gets you to this point. Either there is a risk to health and safety, and if that's real and genuine, then something needs to be done about it. There's a duty of care on all parties, and there's a regulator which applies to all parties. So if there is a genuine risk to health and safety, as you've posited, it's one of the two scenarios, then something needs to be done. And we should have a chat about what the mechanisms are for that. It's challenging, to be sure, but there are options. And if there is not a genuine risk to health and safety, well, then that's important. If that is the case, that there is no evidence of a true, genuinely held risk to health and safety, I think that gets you to the position that we've been discussing so far on the podcast, which is that there is no reason then not to have access and egress onto the site by third parties, i.e. supplementary labour or contractors or others who might be coming on site.
Look, let's unpack that, Steve, because I think that throws up a whole range of different issues that would be good to sort of go a little bit deeper on. Let's start, you mentioned different sources of duties for different people, and obviously the employer, the host, the principal has some. Let's come back to that in a moment.
Sure.
Let's focus on the unions. Now, it is often, I say union or any organiser of a picket, but the entity that is organising the picket, they are the entity that has brought the people to that location. They are the reason for, let's call it, the event.
Yes.
What obligation does that person, the organiser, have to ensure they're maintaining a safe environment for people to go about their usual business?
Well, either at common law or because of the Occupational Health and Safety or Work Health and Safety Act, depending on the state that you're in, there is a duty of care to make sure that you're not doing things which put other people's health and safety at risk. Shouting fire in a crowded cinema is a crime. Whether you are doing that for politically held reasons or cultural reasons or community reasons or not, putting people's health and safety at risk is an offence. And so we've got to be, really clear that this applies as well to third parties. They're not outside the law. They're not outside the Work Health and Safety Act. A duty of care is owed by them as well. The challenge, of course, your next question will be, so what can you do about it? The challenge, of course, is work health and safety law, occupational health and safety law, is a regulated environment. It requires the active engagement of third-party regulators, the WorkSafe, SafeWork New South Wales, Workplace Health and Safety Queensland. So what's important, I suppose, is for stakeholders to remind and engage with those regulators to identify if in scenario one we've got genuine risks to health and safety, the sort of conduct that Em took us through, there is a role to play for those regulators to be regulating the risks to health and safety that arise. If we think of the counterfactual, an employer who permits groups of employees to target and harass and prevent others performing work within the workplace, this would be just a black and white case of intervention from the regulator. So the challenge under work health and safety law is there are no real private rights. You have to go elsewhere. You have to look to the common law to try and enforce, your statutory protections. But within the work health and safety regime, there is a regulator, and that regulator has a role to play. And I think, first and foremost, we shouldn't forget that.
It's an important reminder, Steve, because often the people tasked with dealing with the obstructive picket when it arises are more of the sort of IR frame of mind. But it's a good reminder, there are some mechanisms here on the safety front that are worth reminding the organisers of the picket of, and perhaps even considering getting the help of the regulator to come down and experience the work site and what's going on the picket line. And I've been to many that they can be confronting.
Oh, indeed.
You might find that we get some swift action out of that. But I think that's an area worth investing in.
And I suppose, just to finish that thought, we are chatting here today about how to sort of frame your, let's call it strategic thinking about how to get ahead of this story and how to make sure that you can keep your business operating, notwithstanding that you might be going through bargaining. I suppose that's the reason we're thinking about this.
Yeah.
And I just think it's essential that in your checklist, for those of you who are looking ahead and thinking this might be something that applies to my business, in your checklist, I think that is number one on the checklist, to make sure you have that engagement, perhaps early and perhaps during. Now, whether that bears fruit or not is really then in the hands of somebody else, the hands of the regulator. But I think it's essential that you've shown you've taken that step to then sort of unlock, if you like, the other opportunities that might arise for other legal protections or other legal rights you might have.
Well, let's assume we've done that, Steve.
Sure.
And we've engaged with the organisers of the picket. We've reminded them of their obligations,
Indeed.
our expectations. Maybe we've invited the inspector down to try and help us.
And we should say, Ro, just before you go to the next point, we've had good experience from clients who've done this, right, who have acknowledged the practical reality of the fact that a picket will occur, but have taken steps to engage with, let's say, the unions in the particular cases I'm thinking of, proactively, and said, well, we just need to make sure that we can do the things that are essential to have a safe workplace, and we're not doing the things that create risk to health and safety.
Yes.
And that is a possible pathway. That is not, we shouldn't, I suppose, presume ill intent. There is a possible pathway of negotiation. It's not going to apply all the time, and I think that gets us to where to from here.
And you've got a much better prospect of that working the earlier you do it, ideally pre-picket, if possible.
I agree.
Often you're given some signposting that it's going to happen.
Yeah.
So, but moving on to that next point, Steve, let's say we've done all those things.
Yeah.
But you have, let's say it's an employee, let's say it's a contractor, a labour hire worker, comes to you and says, okay, I've gotten all your correspondence that says there's a picket, we're providing for safe access and egress, there is security personnel there to assist you. I'm still scared.
Sure.
I am concerned for my safety. There's physical obstruction or there's verbal intimidation.
Yeah.
I don't want to come across. My employer said I don't have to.
Sure.
What can we do in that scenario? It strikes me as something that might impose an obligation on that person to give some details about the sources of their concern. Would you agree with that, Steve?
I would absolutely agree.
Yeah.
I guess let's come at this from two angles. So an individual says to their host employer, I feel safe at work, or I feel safe coming to work. There's a positive duty to explain the circumstances of that and the reasons for that. Equally, let's just think again of a counterfactual. Someone says, I'm not happy to come to work because of the experience I have in my team. I feel these psychosocial risks. That worker would be expected to give you some information so that you can take steps and resolve it. And the same is true if a third party is doing that. So thinking of the individual, we should be clear that there's an expectation that they, as part of your workforce, whether directly employed or not, have a duty to take reasonable care for themselves and to help you meet your duties of care. So I suppose that deals with situation number one. And I only raise that, again, not to be unrealistic that this is a simple thing, but it is at least a foundation to have that discussion. And then if we think of the corporate to corporate questions, so the third-party labour hire provider, the third-party maintenance contractor, the one who's coming in to supplement the labour that might be out on the grass not working, there's a positive duty of care under health and safety law to consult, coordinate and cooperate between entities. So again, looking for sort of positive hooks and clear legal foundations to engage in what would otherwise be kind of common sense processes of trying to resolve this. The foundation is there in health and safety law. And again, these are shared common obligations, criminal sanction for not complying with them. And so again, there's a good foundation to have sensible discussions in these circumstances.
Which is an important reminder, Steve, because again, these scenarios, they happen often. We deal with them regularly. And so if an individual comes to the principal, the host, the employer and says, I'm fearful for my safety, I can't cross, then Steve, to your point, well, they have a responsibility and obligation to provide information. Why? Who said what to you? What did you observe? Who are the people that did those things? When did those things happen? Now, in my experience, there's a great degree of hesitancy in providing that information, sometimes for good reason, sometimes that reasoning is not as clear. But to your point, Steve, there are legislative obligations to compel it, and I think that's, again, another area worth investing in. Keen on your point about the regulator, Steve. Again, in my experience, not all that common to see inspectors down the picket line, at least in the matters that I've worked on. What would be your advice to employers that are dealing with an obstructive and potentially violent picket there?
Well, first I would say, presume good intent. You should approach the regulator in good faith, I think, and try to get their intervention to try and resolve these issues. But there is it's fair to acknowledge an institutional reluctance, I suppose, to engage in what's seen to be a sort of an other world. The industrial world isn't the safety world. I don't think that's right. I think, conduct which causes a risk to health and safety is unlawful, and it should be unlawful regardless of the context. So, one, presume good intent. Two, have clear evidence, your point earlier, to put to the regulator and to seek regulatory intervention and invite them down and engage with them. And I think all of the proactive thinking about who you're going to call on the day that a truck turns up and blocks access to your distribution centre, which is your best contact at the particular regulator, who's the person you want to engage with, I would be doing that well ahead of time. I think it's challenging in the heat of battle, as it were. Can I make one other point? The exercise of statutory power by a safety regulator carries with it an obligation to exercise that power properly. And there are review rights under health and safety law for a regulator which makes a decision or a regulator which refuses to or does not make a decision. And so I just flag that. I suppose I signpost that. Again, in circumstances where there's a manifest risk to health and safety, there's evidence which shows that it exists, and a reluctance or a failure of a regulator to intervene, there are appeal rights. There are processes that the party can go to try and get some satisfaction. This is not going to be the silver bullet solution to resolving a picket, but I think it's part of the constellation of tools.
It's an element of the
should
response.
have.
Absolutely. And I think an element that probably deserves greater attention than it has perhaps gotten in the past. Because I agree with you, Steve. We are now in a world where I'm not sure it was ever acceptable, but it is even clearer now, societal expectations, the kind of conduct that Em spoke to at the start of the episode, unacceptable. And no one should be required to put up with that.
Indeed.
But it goes on. And so we need to look at all these mechanisms, including what safety law enables us to do in order to respond to these things, which I think is a handy segue, Em, to the legal responses. We should cover those off. So there's obviously a lot of the practical steps we've spoken about with Steve on the safety front, but let's assume that the employer needs some more help. The picket has turned obstructive, it is intimidatory, people are refusing to cross the picket line. What are the options in the Commission and the courts for employers in that scenario?
Thanks, Rohan. So if a picket is obstructive and ongoing and these sorts of unacceptable behaviours are occurring, there are your classic common law industrial torts. So that's heading off to the Supreme Court, not the Fair Work Commission, and seeking, bringing claims that might be nuisance, trespass, interference with contractual relations. There are also Competition and Consumer Act claims relating to secondary boycott. And sometimes the Fair Work Act coercion provisions can also be used to seek, sort of injunctive relief. In
The latter of which being to the federal court, I guess.
To the federal court, which would be, that's right. So, but in fact, in recent years, the Fair Work Commission has become an increasing jurisdiction for seeking relief in relation to obstructive pickets. And that's actually through applications for good faith bargaining orders. Now, Rohan, you're sort of the in-house expert on these kinds of claims.
Yeah, that is something. I think prior to when we would have been maybe pre the early 2010s, I think the automatic response was to go to the courts. So that the state courts, as you mentioned, Em, or the federal court, depending on the causes of action that you're pursuing. We at HSF in particular were a big advocate of looking at the help that the Fair Work Commission can provide in this context. Now, importantly, picketing is not of itself industrial action. If employees are on the picket and they're engaging in a stoppage of work, it might also involve industrial action being the stoppage. But standing on a picket line, obstructing, not obstructing, that itself isn't industrial action. So you can't get help from the Commission pursuant to Section 418 Industrial Action Stop Order. There's no jurisdiction for that. What you can do, though, is go to the Commission in the context of the bargaining that's going on and seek good faith bargaining orders. Now, HSF has on many occasions been successful in securing those orders. The first one was the Forex Brewery dispute back in 2018 that we mentioned. And they're obtained on the basis that obstructive picketing is unlawful, it is unfair and capricious conduct that undermines collective bargaining. Why? Because it involves generally the union operating outside the rules of the game. There are rules of bargaining, things you can do, things you can't do. Lawful industrial pressure can be imposed through the protected industrial action regime. This is moving outside those rules and obtaining an unfair advantage that puts unfair pressure on employers. And for that reason, it's unfair, it's capricious, it undermines collective bargaining. Now, that position has been accepted in many cases now. I think we've run about 4 or 5 of them at HSF. It was a strategy that, in fact, Woolworths rolled out in December of last year. But I think the key point there, Em, is there are lots of different options for dealing with obstructive pickets, intimidatory behaviour and the like. State courts, federal courts, commission. We won't go through the details of all of those. But which is the best option will very much depend on the nature of your dispute. And sometimes, not always, the problem that you're trying to solve is not necessarily the obstructive picket. The problem is the bargaining and the incapacity to get a deal done.
Well, if you solve that, typically the picket goes away.
That's right.
Yeah.
And sometimes it's better focusing on that. Sometimes it's not. Sometimes the picket is causing really significant financial harm. And you're better off in the courts because you might want recompense for that harm. You might want an immediate interlocutory injunction. Those are all options that are available. But I think the point we're very passionate about at HSF is that it is horses for courses. You look at the dispute in front of you, you tailor a solution that's best going to achieve the objectives of the employer in that scenario, and then you run ahead with that. And it's important to look at each dispute through that lens. But importantly, I think, Em, and we've mentioned this a couple of times, pre-planning is really essential for this.
Yep.
If a client comes to us and says, hey, we've had obstruction out the front for 2 days, can you jump in and help? Yeah, sure. We'll probably get you an order within a day or so with the right evidence. But better if you have a clear plan on how to manage this type of conduct before it starts. What are the legal strategies you're going to look at implementing? Which jurisdiction are you going to go with? What evidence do you need in support of that? Who's the person within your organisation that is going to stand at the picket line within earshot of the trucks that are driving in and hear what is said to those people? Super critical, getting that evidence.
Yeah.
How are you, to your point, Steve, how are we going to make that environment for that person safe to perform that role? What security providers do you have access to? Do you have good CCTV in place to get recordings of all of this to use in evidence? Who's tracking the damage that this is causing? Sometimes it's actually hard to work out. What is the financial loss that's triggered by the actual obstruction as opposed to any other industrial action that's going on in the workplace? What are our comms like in terms of the contractors and labour hire and other workers that we're expecting to come into the site? How do we give them that assurance, Steve, that we're actually doing everything that we need to ensure their safety as far as reasonably practicable? What are we saying to the organisers of the picket about their obligations? All of these things are so much easier if you've got a clear plan in place ahead of the picket actually arising. And I think that's the main message from us today. It's for employers, particularly those heading into bargaining rounds, be prepared for this. We are seeing more of it. We are seeing employers that traditionally haven't had to deal with this conduct, having to deal with it for the first time. We do have safety laws that have something to say about all of this conduct, and they can be helpful. They deserve some perhaps greater attention than they've been given in the past. So that's all we really have for you today on today's episode. If you've like to reach out and discuss your plans for how you manage obstructive picketing, do feel free to get in touch. We always love to hear feedback as well on Inside IR. So feel free to send us a comment on LinkedIn, a direct message, or an email to insideir@hsf.com. Otherwise, we look forward to seeing you on our next episode of Inside IR.